Hello everybody, I am Dr. Bharti, working as an Assistant Professor of Law at National Law University, Delhi. Today I will be discussing a module on access to justice under Constitution of India. The objective of this module is to understand the need of special provision for access to justice in India, to know the different constitutional provision supporting the access to justice in India. In addition to all this, we will also look into the judicial trends promoting the access to justice in India. Peace and harmony is very essential for the growth and development of a nation, which can be ensured through fair administration of justice. In a welfaric state like India, where people are known for its diversity, it is the obligation of state to ensure equal administration of justice. Equal administration of justice is very essential ingredient of fair administration of justice. To promote equal administration of justice, irrespective of economic or other disability, the concept of equal access to justice and free legal aid emerged. It promotes the saying that justice should not only be done but seem to be done. The founding father of the Constitution of India had taken a positive note towards doctrine of equal justice, which became apparent on the plain reading of the preamble of the Constitution. It provides for justice to all in all its form, social, economic and political. The preamble promise is further strengthened by Article 14, 21, 22, 32, 39A, 38, 41, 46, 142, 226 and 282 of the Constitution of India. Preamble of the Constitution provides for securing all citizens equality of status and opportunity along with justice, social, economic and political. Both equality and justice are interrelated. Equality promotes justice and justice promotes equality. We cannot expect justice without the support of equality. Equality in a country like India, where difference among people prevail because of social, economic and political factor, is a far cry without the support of provisions like equal access to justice. Legal aid bring less advantageous people at par with affluent counterparts so that they could get equal access to justice. Apart from the preamble, access to justice also gets support from fundamental right provided under Part 3 of the Constitution of India. Fundamental right enshrined in Part 3 of the Constitution are the tool to achieve the objectives laid down under the preamble of the Constitution. These are basic and natural rights which are essential for the growth and development of human being, which ultimately led to the growth and development of a nation. Article 14, 21, 22, 32 and 226 provides for free legal aid. Article 14 provides that the state shall not deny to any citizen equality before law and equal protection of law within the territory of India. Article 14 uses two expressions, equality before the law and equal protection of law. Equality before law is taken from England and equal protection of law is taken from American Constitution. Both this term appear similar, but they have different meaning. Equality before law provides that everybody is equal before law, irrespective of political and economic resources. On the other hand, equal protection of law provides a helping hand in terms of special provision to those people who are at a less advantageous position, so that they could avail the benefit of law as their affluent counterparts are availing, and equality before law could be maintained. In India, because of illiteracy, ignorance, poverty, lack of faith in judicial system, people do not get equal access to justice as their educated and affluent counterparts get. So provision like free legal aid becomes very essential to provide them equal protection of law, which is a fundamental right of every citizen of India. Another supporting provision which is implicit in Article 14 is the principle of odi ultram partem. It provides that other party must be heard before deciding a case against him and before passing any order against him. So it is the duty of state to ensure that every person gets fair representation before court, irrespective of his means or knowledge. That is why free legal aid is implicit in Article 14 of the Constitution of India. Another supporting provision provided in the Constitution of India is Article 21. Article 21 provides that life and liberty of a person cannot be taken away except according to procedure established by law. The Supreme Court in Menka Gandhi versus Union of India held that under Article 21, life and liberty of a person can be taken away only according to the procedure established by law. The procedure which can take away the life and liberty of a person should be just, fair and reasonable. Any procedure established by law which doesn't provide for fair representation before law cannot be termed as just, fair and reasonable. So, it is not authorized to take away the right to life and liberty as provided under Article 21 of the Constitution of India. So, in this case, it was held that the provision and the procedure which doesn't provide for equal representation before court and which doesn't have the provision of free legal aid to those who cannot afford cannot be termed as a just, fair, reasonable procedure which can take away the right and liberty of a person. The Honorable Supreme Court reaffirmed its stand in the case of Hussain Ara Khatun versus Home Secretary to include right to free legal aid in Article 21 of the Constitution. It was held that the right to free legal aid is clearly an essential ingredient of just, fair, reasonable procedure provided under Article 21 of the Constitution of India. This is a constitutional right of every accused person who is unable to engage an advocate because of his indigency that he should be provided free legal aid at the expense of the state. The state is under an obligation to provide a lawyer to an accused person if the circumstances of the case and the need of the justice so requires, provided accused doesn't object to it and he accept and agree to be represented by an advocate appointed by the state. Again, the Honorable Supreme Court reaffirmed the obligation of state to provide free legal aid in the case of M.H. Hoskote versus State of Maharashtra by giving a similar decision. It stated that if a prisoner is unable to exercise his right provided under Constitution and another statute because of his indigency, then it is the duty of the state to provide him free legal aid. Another issue regarding obligation of court to inform about the right to free legal aid was discussed by Honorable Supreme Court in the case of Sukdas versus Union of India. It was held in this case that right to free legal aid is a fundamental right of every accused who cannot afford to hire the services of an advocate, and it is the duty of the state to provide an advocate at state cost if an accused person appearing before him doesn't have means to afford an advocate. And this right is implicit in the requirement of just, fair and reasonable procedure provided under Article 21 to take away the right to life and personal liberty of a person. It was also held that this right cannot be denied to him on the ground that he failed to apply for it. The magistrate is under an obligation to inform every accused who appears before him that he has the right to be represented by an advocate at state cost if he doesn't have means to afford an advocate from his own money. Again, in the case of Muhammad Ajmal Kasab versus State of Maharashtra, the Honorable Supreme Court directed all the magistrates in India to inform all the accused who appear before him the right to free legal aid to which they are entitled to if they don't have means to hire the services of an advocate to represent their case. It was held in this case that the right to legal aid, consult and defend by a legal practitioner arises when a person arrested in connection with a cognizable offence is produced before a magistrate. So, it is the duty and obligation of the magistrate before whom an accused person is produced to inform him that he has a right to be represented by a legal advocate, and if he doesn't have means to hire the services of an advocate, then he is entitled to be represented by an advocate which will be hired by the state, and state will pay his cost and he need not to pay any cost to be represented by an advocate. It ensures equal administration of justice, which is very essential ingredient of fair administration of justice. The right flows from Article 21 and 22 of the Constitution and needs to be strictly enforced. All the magistrates in the country were directed to faithfully discharge this obligation imposed by the Honorable Supreme Court, and if they fail to discharge this obligation, then departmental proceeding can take place against them for failing to discharge their obligation of informing the accused person that they have a right to be represented by a legal advocate at state cost if they don't have money to hire the services of an advocate from their own money.